Now, I'd like to move on to the issue of exemption clauses in breach of contract that starts at page 281 now. And you recall that we talked about exemption clauses before under the first chapter under offer and acceptance at page 127. So on page 281, which deals with exemption clauses, I'd like you to write to the right-hand side of that on your book or your piece of paper. See also page 127, which deals with offer and acceptance and exemption clauses. Exemption clauses are used by parties to the contract to protect them from being sued for negligence or liability for a breach of contract or whatever. And this is explained quite well to you under the purpose of exemption clauses at page 281, that paragraph right under the heading purpose. That tells you why we use exemption clauses. For example, an airline ticket may say, we agree to fly you to Toronto, but if we lose your luggage on the way, we're not responsible for that. That would be called an exemption clause. Or at a baseball game ticket, you go to the baseball game, and there might be, again, in the fine print in the ticket, an exemption clause that says we're not responsible for any injury that may result to you by being at the baseball game. This is all explained on page 281. What I want to talk about here is when these exemption clauses become part of the contract, because under the offer acceptance, there was adequate notice given of the term of the contract to the offeree at the time the contract was made, so it's now part of the contract. So is that the end of the story? If for example, you enter a car park and you've agreed not to sue them if your car is stolen? Well, it's not the end of the story. First of all, the exemption clause has to cover the loss that results in the matter. For example, if you have an exemption clause that's in a car park situation on your ticket that says we're not responsible for any damage to your car, but you park it there and the car's stolen, that exemption clause doesn't apply because your car's not damaged, it's gone. So that exemption clause wouldn't apply to protect the owner of the car park because it's not drawn widely enough. So the book points out at the bottom of page 281 and the top of page 282 that the courts are very strict in their analysis of these exemption clauses as to determine what they protect and what they don't. So if you were going to draw an exemption clause that protected, say, a car park from any type of loss to the car, I guess you'd probably say something to the effect that we're not responsible for any loss or damage occurring to this car in any way whatsoever, by any means whatsoever. We're not responsible at all. That would cover the theft of the car, damage to the car, and so on and so forth, and that would protect the car park. Now, at the bottom of page 282, though, where you may have situations where the court finds the clause so unconscionable that they will not allow the party to protect themselves with it. These are called unconscionable clauses, and it depends on the nature of the contract. Is it a take it or leave it situation? I don't know if a car park situation is a take it or leave it. If I don't like that car park, if I don't like the exemption clause there, I could go somewhere else. But, maybe in an airplane ticket case where the ticket says we're not responsible for death if the plane goes down, that would be seen to be, even though there's adequate notice given, and even though the exemption clause covers the damage, that is death, the court may find that that's so unconscionable that they will not let the party protect itself from that and the breach of the contract resulting. I want to just talk a bit now about the next section called types of remedies. Where you have a breach of the contract, you get a toolkit of remedies. The big tool in the kit is called damages. There's another remedy called specific performance and another one called quantum merit that we talked about at another time, and I may not talk about again too much now. I just want to talk briefly about the purpose of award of damages. So you got a breach of the promise. You got how much money do you get? How do you calculate that? Because that's all that the courts is going to give you usually is money. If you can say, look, the other side breached the contract here. He delivered tomatoes when I asked for oranges. How do we calculate that? Well, as the book points out, the purpose of award of damages is to place the injured party in the position he would have been if the contract had been properly completed. Again, I'll read that to you. It's on page 283. The purpose of awarded damages. Damages are awarded to place the injured party in the position he would have been if the contract had been completed. So if I ordered oranges from you and you deliver me tomatoes, and I sue you, I would want to show how much profit I would have made if you would have given me the oranges and not the tomatoes. And if I could show what I would have made as opposed to the tomatoes or whatever, the court will give me that. They'll give me my lost profit. This is different than under undue influence and misrepresentation, where the court simply puts you back to where you were before you got into the contract, that is giving you money back that you may have paid the other side. This puts you in a situation of giving you your profit that you lost because of the failure of the party to keep its promise. And as the book points out, the loss must flow from the breach. This is on page 284. To qualify for recovery, damages must flow naturally from the breach, and any lost profit would flow naturally from the breach. If you say, well, look, if I would have had oranges, I would have sold them for this price, and you just simple accounting. But if, for example, if I order oranges from you and you ship me tomatoes, and I end up having a nervous breakdown over it and end up going into the hospital, I can't sue for that because that wouldn't naturally flow from the breach. But lost profits usually naturally flows from the breach. Also, as the book points out, top of page 285, though, your damages, if you suffer damages, if the other party has breached the contract, you must stop the bleeding. This is called mitigating your damages. At the top of page 285, there's the heading, damages must be mitigated. Please read that. What that means is, in my terminology, is if you're bleeding from the, and I'm using that figuratively, if you're losing money, you have to try to stop losing the money. So, for example, if I order oranges from you and you deliver me tomatoes and I reject them, and I sue for damages, if you can show that somebody across the street had oranges that I could have bought even cheaper than from you, but I didn't do that, if I didn't buy the same oranges that I was supposed to get from you, even cheaper, you're not going to get any money because you didn't mitigate your damages. You have to go and try to find out, can I stop the loss? That's what this is talking about on page 285.